Good morning, everyone, and welcome to our webinar today. My name's Amy, and I'm the Communications Manager here at morepay. Today, we're going to be talking about Brexit and right to work checks, which is a very hot topic. We've got more than 1,300 people registered for the webinar today, which is why your microphones are muted, just to avoid any background noise. Now, we obviously have a Q&A at the end of the webinar, so we definitely want to hear from you, otherwise we're going to have nothing to talk about in the Q&A. So please drop your questions in the question panel in the GoToWebinar box that you can see there. I think we're going to get a lot of questions, but our expert Carl will do his best to answer as many as he can. If you're facing any technical issues, which I really hope you don't, but if you do, then use that same question box. If I see lots flooded in, then I'll know that we've got an issue and I will do my best to fix it. If it's an issue at your end, don't worry too much because we are recording the webinar and we're going to share it by the end of today. So I'll send you a YouTube link and you can watch the recording at your leisure. You can share it. You can do what you like with it. So don't worry about that. Before we get into the webinar, I just wanted to talk very briefly about morepay. Apologies, morepay customers. I know there's lots of you on the call, so I will keep it nice and brief. But in short, morepay provide payroll and HR software as well as managed services to companies of all shapes and all sizes across the UK. You can see some of the brands there. And we've got more than 10,000 happy customers and we're growing. Our promise is to make payroll and HR easy. And we do that by focusing on 4 key things. So first of all is a simple onboarding. We know that switching to a new provider can be really stressful, so we focus on a stress-free implementation. The other thing is easy to use software, and that's not just for you, but that's also for your employees. The other thing is rich functionality, which basically means our software is jam-packed with features and automation and analytics. And then the last thing is flexible services. So these are tailored to your business and provided by a huge team of in-house payroll and HR experts at morepay. So that's us. So let's get on to the webinar agenda for today. So what are we going to be looking at? Well, we're going to talk through the EU settlement scheme. We're going to explain the UK's point-based system. Of course, we're going to look at right to work checks. So what are they and how do you carry them out? We're also going to look at what your obligations are now, some of the things that you're going to need to do to prepare, and also what your obligations are going to be beyond June the 30th, so when that EU settlement scheme deadline happens. So let's go to your presenter for today. So today we've got a very seasoned webinar host, which is Carl Hardcastle. He's a very experienced employment law consultant with more than 20 years experience in this area. He's been with morepay for over a decade, 10 very happy years, I'm sure. And the great thing about Carl is he's always receiving Trustpilot reviews left, right and centre because our customers love him for his professional advice and just always being wonderful and friendly and polite. And yeah, he embodies everything that morepay thinks is important. So I'm going to hand over to Carl now and he's going to take you through our webinar topic today, which is Brexit and right to work checks. Right to work checks. Good morning, Carl.
Good morning, Amy. Thank you very much for that. And first of all, a very warm welcome to this lovely spring day webinar. Before we get into the introduction, can I just assure you I did not write that slide. That was written by other people. Yeah, of course, it's factually true about the qualifications and things like that, but the 5-star Trustpilot, that's Amy's work and not mine. I promise you I'm not that paid. Okay, a quick introduction. Well, first of all, I'm keen today is a two-way session. Yes, of course, I'm going to sit for the next 35 minutes or so, 30 minutes or so, and discuss what's happening when it comes to right to work checks, Brexit, paperwork and things like that. But I'm also very keen that this is a two-way session. Yes, of course, Amy's already said this and I'll repeat it. It's key that we get your questions back. A webinar only comes to life when it's a two-way process. If it's just a guy prattling on for half an hour, it can be quite flat. So please feel free to use the Q&A box as suggested by Amy. What we've done today is tried to keep it simple and straightforward. Immigration is incredibly complex. It's far more complex than you probably need to know. So what we've done today is keep it simple and straightforward and uncluttered. Okay, so that's the key. The other key is you do not have to make notes, as Amy's already suggested. A copy of this webinar is available via a link, so you can hear it back again. And likewise, that will be not only my voice, and I'm sorry about that, but somebody's got to come from Yorkshire. But also you'll have a chance to have a look at the slides all over again. So don't make notes. Okay, right. Brexit. That's the word that was most feared after the word COVID, wasn't it? So we're back on Brexit today. It's been 5 years in the making. We have had many questions here at morepay over the last 5 years to say, well, what shall I be doing? And the answer is, we don't know. Nobody knew until fairly recently. So we now do know, or we've got a clearer understanding of what we need to be doing. So this morning, I'm going to spend some time doing a little bit of a reminder, just to say how we got here. And I'm also going to be doing a little bit of where we are and where we think we are going forward. We know where we are until June of this year, but there's some certain unknowns after that I'll spend a little bit of time this morning going through. Okay, so let's have a look at this slide. And I don't intend to read every slide. As I said previously, these slides are available. A reminder, Brexit. The UK left the EU at the end of January 2020. We all know that. We had a 12-month period of grace that ended at the back end, 31st of December on 2020. And for you, for your EU, EEA and Swiss national employees. I'll spend a little bit of time describing those, but basically it's Europeans. Okay. The final point on that slide I want to draw attention to. Here at morepay, we can answer, the HR services team can answer 99% of your immigration issues. What we can't do is get into infinite detail. Now, I know what you're going to say. You say, I've joined this webinar expecting to have full details of immigration and right to work and things like that. And on the first slide is a bit of a disclaimer. The reason I'm saying that is not because I'm bottling it. Webinars are generic advice. With immigration, you can get yourself into hot water very quickly. I think currently, if you are caught employing a member of staff that has no right to work in the UK, there's a £20,000 fine and up to 5 years imprisonment. So the reason I'm saying we cannot provide immigration law advice, we can give generic advice, but if you've got a guy or a female with very, very detailed immigration status, you need professional advice. Today's a webinar on the generics and not the detailed advice. Okay, that done. Can I click onto the second slide now about the reminder of EU, EEA and Switzerland? Okay, I am not going to dwell reading through all those names that you can see on there. Those countries you know about, pre-2020, anybody from that region could come and work in the UK and also vice versa. Okay, total free movement. Clearly, that is no more. It's been one in a generation thing. Everybody accepts that. But over the last generation, when people have come to the UK to seek work from Europe, there's been a lot of churn. Many EU nationals have moved to the UK and made UK their home. So when Brexit was announced, the government had to do something. It couldn't quite simply say we need to expatriate you all back to your original countries. The NHS would have ground to a halt. Factories, offices, care homes would have ceased functioning. So something had to be done. So over the last 5 years, the government has negotiated, and if we can click onto the next slide, it's the EU settlement scheme. Okay, again, we've had hints of this since 2006 or 16, since we voted to leave. We've had many questions over the last 5 years, and only now do we have a degree of clarity. Okay, I'm going to spend some time reading this slide because I think this slide is one of the most important ones in the deck, because any EU or EEA or Swiss national that's currently in the UK and currently working and has been working for several years, this is the slide you need to know to take away from this. So the government has announced the EU settlement scheme, and it falls into two clear divisions. The first division is the settled status. So if you've got an applicant who has resided in the UK for a continuous period of 5 years, okay, they have what's known as indefinite leave to remain. So they've got settled status. So what should happen over the next few months, and again, future slides will reinforce this, but over the next few months, your EU nationals that work for you should be applying for settled status. That will be the majority of your EU national staff. So they will apply to the government, and I'll come back to that, but they apply to the government, get their settled status, and they will continue to work seamlessly until they retire or leave your business. That's the easy bit. Okay, the pre-settled status. Again, let me have a brief look at that. That is for EU nationals that have been in the UK for less than 5 years by the 31st of December 2020. So what they're saying is, I've been here for 3 years, I don't have the settled status, which is 5 years. I have the pre-settled status, which is up to 5 years, and therefore they apply for pre-settled status, and they can continue to work absolutely normally in your business with that qualification. And when they get 5 years, they will get the indefinite leave to remain. So your EU nationals need to be getting one of these two statuses. You'll note from there, I've not given any details of how to apply for settled status, and that's done deliberately. The reason is, it's not for you to do. I'll come on to it in a little while, but your staff should be doing it themselves. If you grab your EU nationals, sit them down and say, you need to be following this link, you need to apply here, then all of a sudden, as employers, you are doing indirect discrimination because you're treating them differently to your UK nationals. So what you might want to do is, and again, there's a slide in the deck that's coming up, is explain to your staff, all of your staff, they need to make sure that to find out if it's relevant to them, and if so, they need to have this in place prior to 30th of June 2021. So we've got from officially January of this year, but we're sat here in April, they've got until the 30th of June 2021 to make their application known to have either pre-settled or settled status. And if you've got a record of that on your HR files, that's all you need to do. So I'll come back to the grace period because there's rumours it's going to be extended. It's like everybody doing their homework, they leave it till the last minute. The government have made noises that not a lot of people have applied early, which means a lot of people are going to apply late, and that deadline may get extended. But right now, you don't need to do a thing until the 30th of June. So that's the EU settlement scheme. And I guess that's going to encapsulate possibly 80–90% of your immigration problems that you've got to deal with as HR professionals. That's people that are already here. That's people from Poland, Spain, Portugal, wherever that have been here, albeit 2 years, 4 years, 6 years, 20 years. They apply for settled status. You get a copy of that on their HR file, and that's all you need to worry about. Okay, the UK points-based immigration system. This is the new immigration system. I don't want to use any political words. You may feel Brexit has been fantastic for immigration. You may feel Brexit has been disastrous for immigration. You may sit on a spectrum between those 2 points. And we're certainly not political at morepay, but what we will do is deliver facts. The UK points-based immigration system, which means we still, in the United Kingdom, we can get foreign workers to come and work in the United Kingdom, but previously they had to either come from the EU or the EU area, or they had to be skilled. The EU area has now been shut off post-Brexit. And again, you may feel that's wonderful, you may feel that's disastrous, or alternatively, you may feel that that's a problem. But what I will say, the only way you can now get foreign labour into the United Kingdom is via the skills-based system, the points-based system. Okay, so let me read this slide. I'm going to kind of skim over it because it's relevant, but it's going to be relevant to very few of the, I forget the figure Amy said, but it was 1,300 people that are listening to this broadcast. It's got to be on skills. So number one, the first point is you can't just do it. You'll have to be now required to hold an approved Home Office sponsor license. So you've got to meet certain criteria. The second point, this can be obtained through an online application process. Well, again, I've got to be careful. The government has now put everything online. Previously, it was a paper-based system and it was a nightmare, but now it's online. It's reasonably painless, and I emphasise the word reasonableness. It's doing a lot of heavy lifting in that sentence, I promise you. So any person you want to hire from outside the UK will need a visa. And the most popular route to attain a visa will likely be the skilled worker route. So the takeaway from this slide, okay, is that if you're requiring care home workers, if you're requiring somebody to work in your garage, if you're requiring somebody to deliver leaflets, the answer is no chance. If you're looking for a nuclear physicist, then there's a high chance that you can actually recruit abroad and get into the United Kingdom. But even so, it requires applicants to attain 70 points to be eligible for a visa. I'm not going to go into what those 70 points are, but it's a totting up system, skills, qualification, experience, but it's fairly highbrow. If you are one of our regular SMEs, it won't be relevant to you. If you're one of our specialist SMEs, it might be relevant to you. And while I'm here, just let me briefly mention that our advice line runs 24 hours a day, 365 days a year. Please call us. If you're not sure about somebody's immigration status or what skills and qualifications you need, give us a call. That's what we're here, that's what we're to help with. Again, with the caveat is we are employment law, HR people on our side of the business, rather than immigration and employers, experts. Okay, so what you need to do to avoid those heavy fines and avoid that time in prison is every single employee of yours, albeit a UK national, a foreign national, when they come to work with you or continue to work with you, they need some kind of right to work checks. So let's look at some general info before I drill down into a little bit of detail. First point, employers must conduct a right to work check before employing someone to ensure they are legally permitted to work in the UK. That's true. If you just say to your foreign nationals, I need to see your passport, and the guy you've known all your life down the road that you went to school with, I don't need to see your passport, you're being discriminatory. Everybody prior to employment, or at least on the very first day of their employment, must bring the relevant documentation to confirm that they have an eligibility to work in the UK. Okay, number 2 on that slide, or the second point down, there are 2 types of documents when it comes to providing legality to work. The first document is the forever document, such as a UK passport or settled status or whatever. That's going to never change. If you set somebody on that's a UK national and they're bringing the British passport on day 1, then there's a fair chance they're still going to be British in 10 years' time, 20 years' time. So that's document A. Document B is the documents or the visas that are time dependent. Typical examples are student visas that can have, they'll be allowed to work for 16 hours out of term time until 2022, 2023, whenever. They have the right to work now. As HR professionals, you should be making diary notes and creating HR evidence that will expire on whatever date in 22, 23, etc. So just because they're okay to be legally working now does not necessarily be reason to believe they're going to be working legally in 2 or 3 years' time. So 2 types of documents. The third tick down there on the screen you can see before you is it's always best to at least do a manual check. And I'll go on to that. A manual check is literally just that. They bring in an original document. We hear lots of excuses like my solicitor has got my passport, so here's a photocopy. No, you need to see a manual check of the original document. Best practice is your photocopy. If it is a passport, the front page saying that they're I'll pick UK. They're a UK national. You need to then take a photocopy of the page where we've got their face, date of birth. You know, it's the one that you always hand over when you're about to board a plane, that page. And thirdly, if they've got any visas, and this will apply to foreign nationals, you need to make a permanent record of that. What also you need to do is I'd write on that in the HR file that whatever your employee, HR professional that's done the checks, that they sign to say that they've seen the original. So in the event that you do get Home Office on board, they will be able to or you will be able to demonstrate that you've done proper checking, and here's evidence and here's proof. So we've seen the original, we've photocopied the relevant pages, ideally in colour if we can nowadays, and that will be our defence in the event that we are found to be employing somebody that's not legally allowed to work here. While I'm talking about that, you are not supposed to be experts on forgery. If the Home Office comes on your site and finds out that you've been supplied forged documents, the liability does not lie with you. You are HR professionals, you are business owners, you are not experts in counter surveillance on forged documents. As long as the documents are not obvious, you're pretty much home and dry. Okay, let's go on to the Home Office check, which is the third point on there. If you have any doubt, there is a Home Office checking service. It's an online checking service where you can input details of where you need to be, i.e. employee's name, date of birth, etc., etc., and you will then get a web page to say either yes, they're happy that they can work, no, they definitely cannot work, or alternatively, you'll often get a bit of a fudge page which will say you need to make your own checks, which is kind of not helpful. But what I would do is point at the fourth tick down, conducting in either an inline check with the Home Office guidance. It will provide a statutory excuse that the right to work checks have taken place. So if you get the green light from the Home Office, take a copy of that, put it on the HR file, and in the event that the Home Office comes onto your site, inspects your documents and finds out that you've employed somebody illegally, your defence was, Mr. Home Office person, we checked with the Home Office and you said it was okay. So that's a really important takeaway from this slide. Do your manual checks, be thorough with your manual checks. Any doubt, go to the Home Office online, get their check, create a copy of that and put it on file. And if you find yourself in hot water, your defence would be, I asked the Home Office who are prosecuting me, and the Home Office are the ones that said it was fine for this person to work. So that's an important point to make. Okay, right, the fourth point before we move on is the government will list on their website the correct documents that you need to see for somebody to work in the UK. I'm saying that for two reasons. The first reason is we see a lot of people bringing in national insurance cards, driving licenses, all the periphery around employment and around the legislation. You can be deceived. I said previously that oh, well, I don't have it on me now, just let me work for the next week. It's in my right to work is in my other court, it's with my solicitor. So on the government website is a list of documents you need to see. Okay. While I'm talking about that, I just want to flip over to say that you shouldn't be making it more erroneous for a member of your foreign staff to be seeking work in the United Kingdom. So what do I mean by that? If you say to a UK national, bring in your passport, okay, and if you say to a Polish national, bring in your passport, bring in your driving license, bring in your right to work, bring in your visa, bring me a gas bill, then all of a sudden you've got indirect discrimination. You're finding it more difficult for a foreign national to have work than you are for a UK national. So that's an important point to make of need to understand the correct documents, which ones you should be asking for, which ones are irrelevant because A, they don't prove anything, or B, you're asking too many questions and it can be discriminatory. Okay, let's look at the grace period. So if we could just move on, please, Amy, to the next slide. Okay. I could read this, but I've got one eye on the clock, and I appreciate you're all busy people. But after saying that, it's important that we get to a little bit of depth without sending you to sleep. Not going to read it. Basically, as I said previously at the top of this presentation, you can continue to employ your EU, EEA and Swiss national employees until the end of June. So from January, February, March, and here we are in April, there is effectively no need for you to do anything, if very little. Sure, we're going to come on to a slide that talks about sending out supportive messages and facilitation messages and how can I help, but you need to do it light touch. The danger is that your Polish workers, your Spanish workers, your German workers are being harassed due to their nationality. So what you might want to do is put out a general email to all staff just to remind everybody that if you need to get your settled status sorted, you've got until the end of June to do it. The second point, employing EU, EEA and Swiss national employees, that is new starters. Please beware with new recruits. If somebody was not in the United Kingdom before Brexit, certainly before the end of the transition period, then you need to be very, very careful going forward about how you employ people. If they've got skills and it's a skills visa, and we've talked about that, that is absolutely fine. But if they've just come over from Portugal, Italy, Germany in July kind of last year, it should be fine. If they come over in February of this year, we need to have a serious look at that. We need to drill down. We need to understand why they feel that they can work in the UK. What is their application? What is their status? What is the points-based immigration system based on? So you foreign nationals, please pay extra attention. We've got fairly lax over the last generation that if somebody walks in your office with a Polish passport, then that's absolutely fine, they can work. If somebody walks in your office now looking for a job with a Polish passport or any other European passport, you need to be having a serious look of their ability to work in the UK. Okay, let's click onto the next slide about what to do to prepare. Okay, the key thing is that we try and get ahead of the game. The danger is we hit 1st of July this year. You've sent out some general emails saying, please can you ensure that you'll get settled status, and nothing's happened. The last thing we want, and we don't think it will happen, is for the government to make an announcement to say that any EU national without settled status or part settled status is no longer employed in the UK. So the first thing we need to do, and again, I'm going over old ground now, but it's important to mention it, we need to support your employees. We need to provide encouragement and guidance on how they can apply for settled status. We can provide information on your workers about the UK points-based immigration system. The UK government has provided online support for employers and employees. It doesn't say employees on that site, but it's certainly there. And there are downloadable presentation leaflets and courses that offer guidance to support for employees. And again, this is where you're going to come into your own as HR professionals. Your senior management team need to know they've got some continuity of business, continuity of service with your workers. It's key that you start putting in the groundwork now, saying to all your staff, but particularly your EU nationals, have you done this? Would you like some guidance? Would you like some support? We can't do it for you. We can't make an application for you. But what we can do is make sure that come 1st of July, that you're in a position where it's boring. And believe me, in employment law, boring is good. Where they just click over, nothing happens, they turn up to work, they do the work, they get paid, and it's boring. Okay, so I've talked a little bit about how to support, but we don't harass. We kind of guide people through it rather than force people through it. So what happens with recruitment going forward? We need to get organised now. It says that in the headline. I know that, but you need to change your policies. You need to change your practices. You maybe need to deliver training to your other HR professionals. That this is for brand new foreign recruits. Anybody that's still not a UK employee or has settled status, you need to do quite a lot of checks when it comes to employing new staff. This slide, again, Amy's going to beat me up now because we're now at 10:30. So I'm going to kind of whiz over it. It's basically anybody that's got very specialist organisations. So if you need to recruit doctors, astrophysicists, Premiership footballers, and I appreciate I've probably said Premiership footballers at the wrong time with the current news, what's happening at the moment. But basically, if you need to recruit foreign labour, you need to jump through quite a few hoops. And again, we can take you through that, but it's perhaps best taking you through that offline, because I am aware of the people that are listening today. It probably will not apply to them. But talk to us. As I say, the advice line runs 24/7, 365. Discuss, and we'll certainly help you with that as much as we can. Okay, so let's whiz on to what to expect after the 30th of June. Okay, now the next slide that Amy's going to shortly move on to is kind of the last slide before we get into the Q&A. So what happens after the 30th of June? I'm going to read through this, but the bullet point at the bottom is possibly the biggest point on this slide. So after the 30th of June, there will be no need to undertake retrospective checks for your EU, EEA and Swiss nationals that had employment before the 30th of June, etc. So if you've got settled status, if you've made that check, you're confident that they are who they say they are, that's it, you're home and dry. So if you've got a Portuguese national, a French national, whoever, they provide that detail to you, settled status, put it in the HR file and let that file go dusty. No need to do anything. Second point is you need to protect yourself. I mentioned at the top of this webinar, there's some very hefty fines, there's some very hefty prison sentences. It's keen, or I'd suggest it's keen that you make sure you've got your house in order. So you need a statutory excuse if the initial right checks were undertaken in line with the Home Office guidance. If you've done your manual checks, if you've done your online checks, if you've got permanent copies of those, that's what you need to be doing. Okay, new guidance on conducting checks, nationals after grace period will be provided in advance of the 30th of June by the UK government. Yeah, that's a little caveat. The government have been under extreme pressure with COVID. I appreciate Brexit's been 5 years in coming, but the government are constantly changing the picture as the situation evolves. The two reasons they've been busy with Brexit, and the second reason, the ongoing negotiations with the EU. If you read the newspapers, you'd be led to believe it's a done deal and we're home and dry and the ink is dry in the document. It is not. We've got heads of terms on most situations. The devil is in the detail, so the situation will creep. So the government will still produce new guidance. I'm possibly talking out of school here, and Amy will no doubt tell me off for this. Because it's a moving picture, it wouldn't surprise me if there's another webinar on this subject before we get to the 30th of June. I don't know that for a fact. I'm just surmising. I'm guessing that is because we know certain facts now, but the situation is creeping. The fourth bullet point is a bit of good news. It is unlikely that government will expect businesses to terminate the employment of EU nationals on the 1st of July. So after the 30th of June, famous last words, don't come down the line and hit me, but it is unlikely the government are going to come down hard. If they did, it may cripple the NHS, it may cripple the economy, it may cripple banking. The UK PLC relies a lot now on EU labour, and just to turn the tap off on the 1st of July, I don't think the government's going to do it. But that's my estimation, it's not a fact. And likewise, the final bullet point before we get into some conclusions is the grace period is going to be to the 1st of July, the 30th of June, clearly. That's what the government are sending out officially. Unofficially, there may be a little bit of movement in that. But after saying that, you need to encourage your staff to get their settlement status sorted, and you need evidence of that on file that's happened. Okay, just before we go on to the last slide and we get into the Q&A session, I just want to go over some conclusions and some takeaway points. I appreciate it's kind of been a little bit of PowerPoint this morning. It has to be. This is factual information. This is stuff you need to know. This is stuff you need to retain on file for future reference. So I make no apologies for that. But the takeaway point is expect updates. Needless to say, morepay will keep you updated on that. If you're a client of ours, then you'll receive regular updates. If you're not a client, clearly we'd like you to become a client, so please contact us. Alternatively, if you are not a client and will never be a client, and as I said previously, speaking to a Yorkshireman and they'd like something for nothing, please use our free resource. It's important that you keep up to date, because if you Home Office come visit and you have somebody that doesn't have eligibility to work in the UK, then you're in serious trouble. Okay, so conclusions. First of all, encourage your European staff to get settled status by the end of June. Emphasising the word encourage, please don't harass them. It can be seen as kind of discrimination. The second takeaway point from this presentation, recruitment for unskilled jobs has basically stopped. So if you have vacancies for cleaners, admin assistants, clerical workers, you will only go to the UK labour pool, and that includes settled status people. Global recruitment is possible, but it's complicated and for highly skilled candidates only. I've seen some stuff on the news recently that's been a little bit misleading, but work on the principle, if you've got a job that's paying £20,000–25,000 or less, then you're going to be recruiting from a UK pool. Even probably much far above that. And again, it's a generic webinar, so I've kind of got to pitch it somewhere. The fourth takeaway point before we get to the Q&A session, and I'm coming in at 35 minutes, so I'm pretty much on time. Keep immaculate records. What happens is the government have made Brexit. Again, may agree, disagree, but it's a fact. Brexit has happened. What will happen is the government needs to keep support from its Brexit base, i.e. its supporters. So what you will see happen, and I can promise this, is when June has happened, if June is the final date, there'll be some highbrow prosecutions that will meet all the press and push out a strong message to the voter base and everybody else that we've done Brexit and we will not tolerate EU nationals that have not already been here and got settled status. Please don't that test case be your business. Okay, so keep immaculate records. And the final point, and it's the point to round off the presentation, is get expert immigration advice. If your defence is, I listened to a guy giving a webinar 9 months ago on immigration, and you are in court, that defence will fail. I can promise you that. If you've got a situation that you need specialist immigration lawyers to, then that's what you need to do. It's a specialist subject. This morning I've talked generically, but going forward, if you've got a particular thorny issue, get some serious professional advice. So after about 35, 37 minutes, I come in. So if I can hand back now to Amy, hopefully there's been a few questions and hopefully I can help with that. Thanks, Amy.
Hi, Carl. That was fantastic. Thank you. And yeah, I'm sure we've got lots of questions, so I'll just bring those up now. We may go slightly over here, but don't worry if you need to drop off the call. As mentioned, we'll be sharing the recording by close of play today. So yeah, if you need to get away, then that's no problem. Okay, so one thing to note, which I think Carl has mentioned already, if there are very, very specific questions around immigration, then obviously it is very difficult to answer those, as Carl has said, because you probably need lots and lots of detail. But let's see if there's a few more sort of generic ones. Okay, so can we ask potential staff when they arrived in the UK? I've been advised this could be discriminatory, and that is from Jonathan.
Hi, Jonathan. Good morning. Thanks for your question. It's a very good question. Indeed, it can be discriminatory. How you turn that round is you ask them to check through their employment history. If they say, for the last 5 years, I've worked for the company down the road. Previous to that, I worked at the local school. Then you know they've got 7 years UK work experience. So rather than ask how long you've been in the UK, what you can do, which is it could be deemed discriminatory because you wouldn't ask a UK national that. How long have you been in the UK? They'd just look at you and say, since I was born. How you convert that is you just look through their employment history, and that will give you satisfaction that they've been in the UK for the right amount of period. But needless to say, it's not really your problem, because if you do hire and they are a EU national, the documentation that you're going to be asking for is settled status come June of this year, or July this year, technically. Okay, Jonathan, thanks for that.
We've got a question from Emma. Are employers now allowed to have a copy of an employee's settled or pre-settled status, as I have previously been sent copies by staff and it states it should not be given to employers?
I slightly disagree with this stance. You need to satisfy yourself that you've seen the original and you've taken a copy of the original settled status document. I agree that they shouldn't be handing it over because we're going to get into a certain legal situation where they say they cannot leave because their settlement status is in their HR file and therefore they can't now go and work for another employer. If you have a copy of it and you're happy and you've confirmed that you've seen the original, that's absolutely fine.
Question from Rebecca. If we already have someone on a visa, will we need to have a Home Office sponsor license? And then she's just, oh no, yeah, that was it. Sorry, that's the question.
Okay.
Sorry.
Yeah, okay. I'm going to deflect this one slightly. I need to know what sort of visa it is, if it's a dependent visa, if it's a student visa. But however, if they've got that visa in place, and it's currently in place, then we're coming back to what I said about Type B documents. They're the ones that have got a time frame on them. If they're a EU national, you might want to have a quick 5 minutes with them to explain that what's their intentions with settled status. But ultimately, if they're not an EU national and from outside of the EU area, if they've got a live visa, that visa means they're good to work until the expiry date.
So just to confirm, this is one from Kirsty. So will an employee need a visa if they have settled status?
No, if they're an EU national that have worked in the UK for 5 years or more, and they've got settled status, that's it. No visas, no nothing. Put the documentation on the HR file that I've said. I'm aware I sound like a stuck record, and I guess the majority of people out there will not know the phrase stuck record, so maybe I'm showing my age. But once you've got settled status, once you've got eligibility to work, stick it on a file, and that's all you need to do forever.
Okey-doke. Got a question from Pauline. It's quite specific to industry, but we'll ask it. I think it's a good one. So how will this affect theatres employing freelance actors and creatives? Does the immigration points scheme apply?
The takeaway word out of that sentence is freelance. Freelance means that they are not employed by you, and you've only got to worry about your employees when it comes to their immigration or their legal status. If they're self-employed and are submitting an invoice, then you're fine to continue. They might be okay to work in the UK. They might not be okay to work in the UK. You can do some due diligence, but they are not your employees. They have the same status as your window cleaner or the guy that comes and services your photocopier. They're not employed by you. So true freelancers, you don't need to ask their UK status.
Okie doke. Question from Dakshini. If we obtain an EU settled status letter, should we still do a Home Office online check?
The answer is it depends. If you have somebody with 5 years work history, if you're confident that the settled status is adequate and proper, then please pop it on file. No need to do a kind of an online check with Home Office. If you think there is something that's a bit questionable, and I'm not suggesting that you'd employ anybody that's questionable, but nevertheless, if you've got a doubt, please go through the Home Office check-in service and maintain a copy of that. And in the event it turns out that you have been supplied forged documents or something like that, then you've got a statutory defence. So the answer is, the answer is quite simply, if you've got long work history, you believe the employee, you've got the original settled status document, you've taken a copy of and handed the original back, no need to do any further checking. If there's something, if the hairs on the back of your neck are standing up, then I suggest you contact the Home Office check-in service.
Yeah, okay. Good question from Kate around, because of the context of COVID and the challenge in seeing original documents, is it currently acceptable to accept a scan or a photo of a passport just because it is difficult to see those original docs?
And that's a very, very, very good question, and it's one I've not heard before. The answer is you may have a defence. We're living in COVID times. What happens is you'll get taken to tribunal, it'll go to an appeal court, and a judge in 2 or 3 years' time will decide if it's the correct or incorrect thing to do. What I will say is I agree with you. We should be checking original documents as much as we can. But if we're in a situation that we can't, we need to be taking very accurate copies of that and an explanation that we couldn't take an original due to COVID. And I would suggest that you put a note in your diary. Who knows when that's going to be, but you do need to see the original slightly down the path.
Yeah, we've had similar questions from another Kate and a Becky, so hopefully that answers that for you. A question from Amanda. For existing staff whose right to work has already been ascertained, does it need to be rechecked?
No, if we've got permanent status sorted, if we've got the settlement status sorted, no need to do any more checking.
Yeah.
If, however, we've got somebody on a student visa, then we need to go back at that at the expiry dates or the spouse visa or all the other visas that are time dependent.
Yeah, okay. Perhaps we've had quite a lot of questions on that one around just seeing original documents, and quite a few people obviously got that challenge of working from home and they've been unable to see things. So lots of questions on that. On what basis can seasonal EU workers be employed? And that's from Robin.
Okay, Robin, thanks for your question, first of all. It depends. I've started every single answer with "it depends," and this is I'm coming back to it, which is not great. If they have been seasonal workers and they've been in the United Kingdom for many, many years, you can, 5 years or more with settled status. Temporary is not a problem. They can be seasonable. They can pick you through. They can pack Christmas cards or fireworks or whatever business you're in that depends on the season. That's absolutely fine if they're based in the UK, or even not based in the UK but they've got UK settled status and they've been here and worked for many years. Brand new foreign nationals, unless it's part of a very niche scheme that I don't want to talk about because it'll send everybody to sleep, the answer is no. Anybody coming from Portugal now to pick fruit in September, you cannot employ.
Yeah, okay. A good question here from Anise. So how do we inquire about settlement status of employees without running the risk of discrimination? Have we got any top tips?
Yeah, quite simply, we send out a letter to everybody, or an email, or a WhatsApp message group, or however you communicate with all your staff, okay? And what you say is, just to remind everybody, including everybody, and you can see what I'm doing now, I'm kind of steering away from somebody saying I'm being picked on due to my nationality. Send out an email, a letter, whatever, to everybody to say, just to let you all aware that the EU status means that Brexit, blah, 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 settled status. If this applies to you, then you need to have this submitted to the HR department no later than the 15th of June. So you've not targeted anybody. You've let everybody know that if it applies to you, get yourself in gear.
Yeah. And if employees haven't provided proof of settled or pre-settled status by the 30th of June, at that point, and this is a question from Michelle, can employees then request it at that point, specifically from those employees?
Yeah, the timeline may slip, as I've kind of hinted at in my presentation, but if it doesn't slip, by the end of June, yes, you need to be saying directly to your staff, I'm concerned that I can no longer employ you going forward. I need, there may be a grace period above the grace period, but I need some evidence that you're making inroads into getting your settled status. But at that point, you can come a little bit more direct with staff, because as you point out, you can point out to them, you can't employ them outside of the law. So they need to be helping themselves to help you to maintain employment.
I'm conscious that we've gone over, but we've still got quite a few more questions. So, Carl, if you've got a few more minutes, we'll just answer a couple more and then we'll wrap things up. So a good question from Alex. If someone's passport expires while they are working for you, do you need to ask them to supply a new copy?
In a word, no. Okay. If you have a UK national and their first day of work, they bring their passport in, or even at interview stage, they bring their passport in, take a copy of it. It'll expire in a few years, 10 years, whenever, but you now know that they are a UK national. You don't have to keep going back to say, are you still from the UK? Are you still from the UK? It's the visas you need to keep an eye on for time lapse. If somebody's Polish, they'll be working the principle they'll be Polish forever. So if their passport expires, you've got the settled status or pre-settled status, then you're home and dry.
Yeah, okay. And then a question from Kirsty. So obviously we talked about this, the need for companies to have like the Home Office sponsor license. Are you able to clarify who needs this? Is this only specific to certain companies, or would everybody need one?
Yeah, everybody that needs to bring in a specialist, a foreign specialist into a UK job will need a license.
Yeah.
However, for the vast majority of companies, such as care homes, retail, restaurants, pubs, remember the time when we had pubs that hopefully we're coming back to now, actually. For the vast, it'll be not relevant, because you will recruit from the UK market, you'll hire from the UK market. It's only if you need an absolute really specialist job, that you'll need a license because you'll need to recruit him from abroad. But yes, every company would need to apply for that license, but it's not relevant to the vast majority of UK companies.
Yeah, okay. Then I think there's probably a little bit of confusion around doing the checks. So if we don't, I know on one of our slides we said that we don't, employees don't have to conduct a retrospective right to work check. So Sarah's asking, how do they know then if their current employees have the right to work in the UK?
Okay, what you do is you do you get your HR files and go through your files. You find out if you've got any holes in there. That's me being polite. I'm sure you haven't. But you go through your HR files, you check your documentation. If there's any gaps or you need to do a retrospective check on an area you're not comfortable with, then that's absolutely fine to do. In the event that you get Home Office on board, you need to have all your ducks in a row when it comes into documentation. So yeah, there's no need to do retrospective checks, but as a right, as an automatic. But if you feel that there's something that's not been done properly first time around, then you need to go back and revisit that.
Yeah, okay. Okay, final question. So a question from Jill. Am I right in understanding that Irish nationals don't need to apply to the settlement scheme?
When you say Irish nationals, I'm assuming you mean Southern Ireland.
Yeah.
And the answer is watch this space. As you've seen from the news, there's a lot of discussion going on about the North Sea border and what government are going to do about it, and how Southern Ireland and Northern Ireland are going to work, because clearly Southern Ireland is in Europe, Northern Ireland is in the UK, and there's a lot of political discussions. So the answer is watch this space, come back for more webinars, get yourself on our email system, and that situation will develop, and I've no doubt it will develop between now and the end of June.
Yeah. Thank you for your questions, everyone. We are just going to wrap the webinar up now. Appreciate we have gone a little bit over time. I'm just going to point you in the direction of some guides that we have created on Brexit and right to work checks. We have sent these out already, but in case you've missed them, I will send them to you as part of the webinar follow-up. So you'll receive a link to each of these guides and a link to the webinar recording, and hopefully they will help and be useful for you to refer to. As Carl mentioned, it might be the case that things change and things evolve and we look to do another webinar. So keep your eye out for that. Obviously, if you get in our emails, then you'll receive an invite as soon as we get something organised. I just want to point you to the Knowledge Centre as well. So that's on our website. All of our webinars, past recordings, upcoming webinars, guides, blog posts, all informed by our payroll and HR experts are on the Knowledge Centre. So you can search for keywords using the search bar, or you can just have a browse around. Everything's free to access and download. So have a good look around in there, whether it's Brexit or other topics. And that's everything from myself and Carl today. So big thank you to Carl for hosting the webinar.
Thank you. Thanks for everybody for listening.
Yeah, and thank you, Carl, for answering lots of questions and for going over there. Much appreciated. I'll wrap the webinar up now. As mentioned, you'll get an email from us today with all the links to the supporting resources. Thanks so much for your time and have a good rest of your day.